It's not ennui, it's criminal disinterest. I mean, I could try to stretch it because 6 months before September 25th would be March 25th. And we are going all the way back to 1993 with the whole Uruguay round. And the whole problem is that nobody really explained what NAFTA had to do with NAFTA and what it had to do with very, very long term commitments that somehow got mistranslated. And nobody's bothered to try to correct for that mistranslation this whole time. But what do I have from the past? The protest should be satisfied. The Judicial Division for Criminal Cases of the Poltava Provincial Court, in considering, by way of causation, on August 23rd, 1966, the case of Koval and Pavlov, who had been convicted by the Kremenchuk People's Court on July 23rd, 1966, under Article 206, Paragraph 2 of the Criminal Code of the Ukrainian SSR, rejected the appeals of the lawyers, affirmed the decision, and entered a special ruling with respect to the lawyer Radchenko. In this ruling, the division stated that the lawyer Radchenko, in conducting Pavlov's defense, ignoring the undoubted guilt of Pavlov, both at the trial and in the causational appeal, raised the question of his acquittal for lack of proof that he had committed a crime. Instead of using legal means and methods of protecting the interest of the defendant, the lawyer Radchenko, ignoring indisputable proof and evidence, in fact started to shield Pavlov and thus was defending a crime. Further, the division stated that the position taken by the lawyer did not help in the search for objective truth and the rendering of a lawful decision. Oh my. It says something about who's allowed to get access to due process these days and who's not. And why certain people just aren't even accused of a crime. I suppose we're not supposed to be able to accrue billing records to wield as weapons in some form of economic terrorism that ends up getting recharacterized as a state secret after you end up going in for treatment for your illness.